Our residents in Cape Town have raised concerns over the Metro's proposed municipal planning by law. The law gives effect to the municipal planning function allocated to municipalities in terms of the Constitution. It refers to requirements set in the Spatial Planning and Land Use Management Act. Mayoral Committee member for Spatial Planning, Eddie Andrews, joins us now to explain more. Good to have you, and thank you very much for your time. The city is proposing some amendments to its municipal planning bylaws. This has received a lukewarm reception from what we are seeing from concerned residents in the Metro. What could have been the misunderstanding about, I suppose, getting buy-in on these changes that you want to bring about?
I think what we need to understand that we are trying to propose some few amendments that would literally ensure the city grows in a sustainable manner, that we're also able to accommodate those who are looking for not just economic opportunities, but primarily housing opportunities, and also asking the question, what barriers do we need to remove as a local sphere of government to ensure that we are a lot more enabling? And these barriers would include, but not limited to, as part of our housing offering, our small-scale rental units, as part of our affordable flats program, where we are allowing, as part of the base zone, in areas where these sort of developments are currently happening unlawfully, to ensure as the regulator that these developments happens responsibly. And that would include looking at legislation that would ensure the compliance of those structures. Another important amendment that we're proposing, where we've seen in communities that are informal settlements, where there are ECDs, these centres don't have the necessary support from the local sphere as the asset owner to proceed and access the subsidy from provincial government. There are issues related to land ownership, lease agreements, and if they do have a lease agreement in place, the proposal there is to waiver the admin penalty because you have erected a structure, a fully compliant ECD, but you don't have the legal the permission from council to do that. So we're looking at waivering that admin penalty with a proviso that you submit a building plan immediately thereafter, just removing one more barrier. So as far back as 2019, when the City of Cape Town commissioned our human settlement strategy, we've seen that about the annual yield for housing would be 50,000 units. The public and the private sector combined yield would be about 20,000. And there's a shortfall. There's a shortfall about then, as far back as 4 or 5 years ago, a shortfall of 30,000 units per annum. And so either you look at that and you ignore that, or you ask the question, how can we help? Because if we don't look at that with a different lens, ensuring that we provide affordable housing opportunities for those living informally, then most certainly we will all be complicit to sustain poverty on poverty. And so that's why our small-scale rental program, we've seen that this sort of developments are quite desirable in the identified areas in the City of Cape Town. But the biggest hurdle that they would face is that the municipal planning bylaw, i.e. development management scheme, does not allow for those sort of developments. Yeah. And what is of concern currently for the City of Cape Town, as I mentioned earlier on, these developments are already happening unlawfully, and it's important to us as the regulator that these developments happen in a compliant manner. We receive a building plan, we process the application, we understand if we have infrastructure capacity, engineers have signed off, and of course, you can then commence with the building. Right. So these are just a few examples that I've referenced in terms of what is proposed in the bylaw, yeah. And I think that is part of the city's layered approach towards densification, where we optimally utilize the land available, okay, where we have capacity.
Let's talk then about the critique, firstly, of the stakeholder engagement process, right? The Newlands Residents Association saying this was just a box-ticking exercise for the city. They're saying, I quote, when you look at the bylaw as a whole, and the amendments to the bylaw as a whole that have taken place over the last 5 or 6 years, what they want is for the city to aggregate more and more power to itself and more denying the residents the right to have a say.
Well, everyone knows that when we have these participatory processes, we engage with the public. And of course, we receive input from the public, and those inputs are, considered and either included. And if it's not included, we then respond to those communities in terms of why we think that this is already covered, or this is not in the best interest of the city as a whole. One particular aspect that we are looking at, for example, if the council has erred in its decision making, the only recourse that we would have would be to go via the court of law to review the decision, and of course they will incur additional costs and also take a lot more time to review the decision. So the proposed amendment here would be to ensure that council now is duly authorized to review that decision and still consult, but make the decision within our planning districts. So you save on legal fees, you save on time, and for those who are in the development space, the more you realize efficiencies in our processes, it definitely there's a financial saving to realize. And the longer you take to make a decision, you can either bankrupt companies or developers or property owners that have procured the service of a professional person. So there's a lot that lives in the bylaw, and the primary thrust of all of this would be to realize efficiencies, to ensure that we have a more efficient process with regards to our land use and building plan development, and also when we do consult, that we are open and transparent with it. One particular reason why we also now have extended the participatory process, because there was a request from Ratepayer Association to saying, look, we need more time, and we definitely can extend the public participatory process, and then have the foreign discussions with yourself. And also, if you need additional engagements, we can engage. So that's interpreted as a tick box exercise in aggregating more power to council. Of course, we hold an entirely different view in terms of what we've embarked on thus far.
The Good Party says in their comments, the amendments to the bylaw reflect an apartheid approach to urban planning and an apartheid mentality to the location of affordable housing. They're saying, for example, the introduction of clauses, which you have mentioned, that provide for the impounding of movable property, really is intended to impound shack buildings and backyard dwelling material.
You know, in politics, there's always a particular agenda that's being advanced, and I think it's often important to read for meaning and read for understanding. And so, when you hear comments that from political parties, I do ask the question: has that been correctly interpreted in this context? Of course, it's not. So perhaps maybe I should explain why that has been proposed as an amendment in the bylaw. So what we've seen is when we have developments and there are no approved plans in place, whether it's a land use application or a building plan application, council will then, of course, go on site and say to the developer, we are sorry, but we have no approvals, and we issue you with a cease works order. We then also in that notice give you an opportunity to submit a building plan application for council to consider it and either approve or refuse the application. And what we've seen historically has happened, developers have blatantly ignored that request, and by the time we return after the expiration date of the notice, if the development is not completed, depending on this, of course, the scale of the development, it's completed or they're far advanced with that. Then we, of course, have to then proceed to the next step and apply for a demolition order, approach the courts again, and this all takes time. And in the meantime, communities are interpreting that entire process that we have to comply with as the local sphere of government, that you are not doing anything. And as a matter of fact, we are actually following the letter of the law. And that process is, we are not benefiting from following that process. So the proposed amendments to confiscate movable property would now, if we issue with a cease works order, and we go back and we see that you have really not complied with the order, we then will be duly authorized to confiscate your movable property And of course, that would stop you dead in your tracks from proceeding unlawfully and completing the building or advancing with much haste to complete the said building. And that's the genesis of that particular amendment. We're very excited about that. Enforcement is a big focus for us as Team Cape Town, primarily because developers have, as I mentioned earlier on, blatantly ignored it and more than happy to pay the administrative penalty. So this is but one, as part of our layered approach towards enforcement, one aspect. Another aspect, we talk to the courts so they can understand the importance of issuing fines that would be seen as a deterrent and not sort of a slap on the wrist of sorts. Also, we will be keen to ask the courts for a dedicated day where we can actually have municipal matters entertained by the courts, because we are entirely dependent on the courts to hear the matter, and we wait. And by the time we get the audience of the court, then, of course, the development is complete, occupied unlawfully, and it's a different conversation entirely. So that's the genesis of that proposed amendment to confiscate movable property.
You don't think, as they put it, it's the wrong remedy to solve an issue of pressure of urbanization and underdevelopment. In fact, they're saying it's almost using a hammer to kill a fly. Take a hammer and you just want to kill a fly, because the issue that you should be addressing is crucial urban issues such as homelessness, transportation, and housing delivery. And impounding of movable property is not the solution to that.
It's a perfect example of conflating issues here. I tried my best to explain what the genesis of that was, but it's now being conflated with the removal of property of people that are living homelessness. That's not what we're doing here. This is a development of sorts. That is a different process entirely, and I think everyone is, including the Good Party, is well aware of the process that council has to approach the courts if you want to act and remove people who have been occupying public open spaces. So it's definitely conflating the issues. When you speak about urban pressures, we are talking about an unauthorized development, a building of some sort, a development that's gone up, and we've served notice on them. We're not talking about people living homelessly and removing the structures they put on public open space.
Yeah. The other issue being raised by one of the residents, that the city is trying to turn the areas, in fact, this one is Daniel September from Kales River, said he believes that the proposal could turn suburbs into slums. And I suppose referring here to the inclusion of automatic additional development rights to residential zoning for building. They're saying, this suggests that this can allow up to 12 affordable rental flats to be added to properties zoned for single residential purposes.
And I think part of my introductory remarks, I spoke about the city's layered approach towards densification. Existing rates currently across the city as a part of the base zoning, single residential 1 and single residential 2, will be to allow for a second and a third dwelling. Those are existing rates now. We've seen also in identified areas that what we call the small-scale rental units are currently being developed unlawfully because there's a big need for accommodation. And here, primarily, I think if we contextualize and profile those tenants, would be what we call the missing middle. These are nurses, our police persons, our educators, all our service people who are now looking for an opportunity to have a housing opportunity. The cost of this, and I think it's important at this moment in time, 24 hours ago when I had the public meeting, I stood up and I presented exactly what the small-scale rental unit. So when we talk about slums, and I presented some pictures about what a small-scale rental unit would look like, it is a proper bricks and mortar structure with window frames and doors and cement tiles on the ceiling with a pitched roof. So that's currently happening, but it's happening unlawfully. So our answer to that would be, how do we regulate, ensure fully compliant structures are being built so we can then exercise our oversight as the regulator to ensure compliant. What we also have seen as once we've done, after we've done our assessment as to why these unauthorized development is happening in these areas, is we've seen that the amount that they're paying per rent, it ranges from anything from from 2,500 rand to about 3,800 rand. It's really quite similar to the amount of money people are paying to live in a shack. Of course, it's a wooden and a corrugated iron structure. And here you can now have an opportunity to live in a more dignified housing opportunity, and also that you can have access to basic services. Often these informal settlements where land has been unlawfully occupied, and it's not public land, we are not allowed to render services within the settlement. We are allowed to render service on the periphery, but we can't if it's privately owned land. So this is a more dignified structure. And I think it's important to again reflect on what I said early on. The annual housing yield 5 years ago was 50,000 units in the city of Cape Town. The combined yield by both the public and the private sector was 20,000. There's a shortfall of 30,000. And the issue of affordability we have to speak about. If you look at what our 70% of people residing in Cape Town earn an income of less than 20,000 rand. They further spend 43% of that income, the disposable income, on what? On transport. To do what? To get to an economic opportunity. So they leave home early, they get home later. So this proposed amendment seeks to now further assist and provide a human settlement offering to those, the missing middle, in a more dignified, humane, fully compliant manner that ensures that as a regulator that all our legislative requirements are met from a land use and a building plan application process. And of course, it happens above board. And then we know people living in more dignified structures.
But is this confined to particular areas? For example, areas that are designated as colored or black areas only?
So what we've seen in terms of the city of Cape Town, these developments have happened. So it's happened in 194 areas. Those areas have been listed. We have listed that in our draft documents as well. So it's across the city of Cape Town. And remember again, densification seeks to respond to quite a few issues in terms of development units per hectare. I spoke about second and third dwelling. I also spoke about multiple dwellings. And this particular question was also asked last night. Why would this not be allowed in an area with high, let's say, for example, in, let's use Constantia or Bishop's Court as an example.
Yeah, they say in the so-called leafy suburbs.
So my response last night in the meeting, and I'll repeat it now, is the following. Remember, this is a sector-led development. Our role as the regulator is to ensure that we are now able to, as our part of the base zoning, that we allow, that we're able to accommodate these sort of developments. So it can happen, but you must submit the building plan. We will have a traffic impact assessment. We will do all our assessments as per the regulations, and then consider the application and then make a decision on it. That's a separate process entirely. So this is not rights that we are approved building plans that we're offering now. This is just sort of the part of the base zoning that you can offer, in SR1, single residential 1 and single residential 2. And also we must reflect on the outcome that we're trying to achieve. I spoke about affordability earlier.
All right, I think we lost Eddie Andrews there, unfortunately, as he was giving us that final reply. Mayoral, a committee member for Spatial Planning, Eddie Andrews there.